much, Hadassah, for this opportunity. I'll be presenting this morning on equal access to justice for women and girls in Cameroon. Access to justice is a right formally recognized in regional and international human rights instruments and conventions. And these conventions and instruments ensuring equal access to justice for women and girls are rooted in the fundamental right to non-discrimination. States parties to these instruments and conventions are bound to draw from them to inform and incorporate that right in their national legislative framework. The state of Cameroon has ratified many of these conventions, and they are fully applicable to women and girls. The Constitution of Cameroon guarantees the equality of all citizens before the law. However, despite these national level efforts, women and girls face significant barriers to justice due to patriarchal cultural norms and practices, corruption, lack of legal awareness, lack of political will to implement even the ratified conventions, stigmatization, and what have you. Serious and multiple violations of the rights of women and girls exist, including widespread discriminatory practices. A gender inequality index actually shows that 94% of people needing gender-based violence services in Cameroon are women and girls. So, it means that in practice, it remains a long road to the full actualization of the right to equal access to justice in Cameroon. So let us look at some of these international legal frameworks on equal access to justice for women and girls. As I said, Cameroon is state party to many of these conventions that guarantee equal access to justice. And to name some of them, you have the Convention on the Elimination of All Forms of Violence Against Women and Girls, you have the FIDA, the General Recommendation number 33, you have Convention on the Rights of the Child, you have the Beijing Platform for Action, you have the ICCPR, you have the ICESCR, you have the Istanbul Convention, the Belém Convention, and the ILO Convention. All of them, they guarantee equal access to justice. And it does not end there. Cameroon has made some national level efforts too. So national legal frameworks on equal access to justice for women and girls in Cameroon begins with its constitution. The constitution is unequivocal about the right to equality and access to justice. It guarantees equal rights, prohibits gender-based discrimination, and ensures fair hearing for all. It declares in the preamble that all persons have inalienable and sacred rights, ensuring equal rights and obligations for all citizens, regardless of sex. The Constitution guarantees fundamental freedoms by committing to the Universal Declaration of Human Rights, the UN Charter, and the African Charter on Human and People's Rights. It guarantees the right to a fair hearing. It prohibits torture and protects physical and moral integrity for all citizens. Cameroon, the state of Cameroon, equally has a law on legal aid. And this law is meant to assist poor people, poor women, who otherwise will not be able to access legal services, so that they can be able to take cases to court. Then, the laws in Cameroon equally guarantee legal capacity for all its citizens. Cameroon has enacted even specific laws to address some aspects of violence and to allow women to make independent financial decisions. A case in point is the Civil Status Registration Ordinance that allows women to do business separate from that of their husbands and even to own separate bank accounts. That is to empower women economically. However, there are many barriers. With all of this level of effort, there are still barriers to access to equal access to justice for women in Cameroon. One is our customary laws that conflict with constitutional equality. You know, traditional and customary law often holds that men are superior to women. In matters of marriage, inheritance, and land rights, the customs frequently discriminate against women. And this brings about economic inequalities orchestrated by these customary practices, and the impact on women's economic rights. If you don't have money, you cannot access justice. There is also corruption within the judicial system that hampers women's equal access to justice. Women also lack awareness of their rights. This prevents them from accessing justice. Many women do not know their legal rights, they don't know when their rights are being violated, and for that reason they don't even have any cause to complain about anything. There is equally failure to implement laws protecting women from violence. As I said, there's lack of political will. Even the conventions that have been ratified are not properly implemented. So it still discriminates. Discriminatory practices against women still go on. A good number of survivors are not aware of the existence of pro bono service providers, and so they don't access them. Like I said, FIDA Cameroon provides a lot of pro bono services, but studies actually showed us that many women do not even know about our services. They need to be sensitized so that they can use us to access legal services. There's lack of collaboration from survivors. The biggest problem we have is lack of collaboration. A survivor will move into your office and complain, but by the time you finish drafting the complaint to take to the legal department, they disappear. You don't see them again. They don't collaborate, and that hampers their access to justice. We also have difficulty of traditional authorities and judicial police officers who investigate these cases. Some of them don't handle it properly. They usually treat GBV cases as private family matters, and so after investigation they close these case files without forwarding them to the legal department for prosecution, and that hampers access to justice. There is a big problem with poverty. We know women are amongst the most poor in Cameroon and even the world over. Because they are poor, that makes it difficult for them to access justice. Cumbersome procedure to access legal aid. As I said before, Cameroon has a law on legal aid, but it is so cumbersome. The procedure to get it is penniless and cumbersome. So many women are discouraged. Some people abandon it half midstream when they try to access it. Then we have women with disabilities, minorities, disadvantaged women. They have difficulties, lots of challenges accessing justice, just because of even their disabilities and other disturbances. Limited financial resources for legal advocacy and support for GBV survivors. FIDA does a lot of advocacy, but the resources are scarce. We need resources to be able to scale up on legal advocacy. Then, protracted nature of trials. Lengthy trials, cases stay in court like forever. This is very discouraging, and it makes people to fall along the way, and they don't move through to prosecution. We also have barriers like inaccessible legal systems for women and girls in remote areas. The most impacted women and girls are in remote areas of this country, and they don't have services around where they live. To come to where there are services is very expensive and long distances, so they cannot access justice. The fear of retribution is one thing too that makes women not to access justice. Survivors are afraid that they may be attacked by the perpetrators, plus the fact that we don't have witness protection, good witness protection processes in place. Witnesses are afraid to come and testify before the court, and when witnesses are not there to testify, it makes investigation difficult. It makes even prosecution difficult. To get the facts, very difficult. Then we have very few legal aid services. The services are there, but they are very few. Survivors are many, but the services are few. The ratio of pro bono lawyers to population and justice claimants remains low. It is higher in urban areas than in rural areas. So the people who are most impacted in the rural areas, they don't get those services. Now, how can we do to scale up? How can we do to dismantle these barriers? I had to proffer some recommendations, starting with recommendations to international development partners. They should scale up funding for lawyers to provide pro bono services. They should allocate grants to non-governmental organizations working on women and girls' rights. They should allocate financial resources for the implementation of legal aid services. They should scale up technical support. The technical support that these organizations give has always been very helpful. I proffered some recommendations to the state of Cameroon, quite a number of them, that they can use to dismantle barriers to access to justice. The state should devise a strategy to create voice and space for the poor and marginalized in the justice system. They should make justice system more responsive to female victims of GBV by carrying out relevant reforms. One-stop justice centers are a creative innovation in that direction. They should simplify the legal aid procedure. How to get this legal aid, as I said, is very cumbersome. If you put any law in place and people cannot benefit from that law, then it defeats the purpose. So legal aid procedure should be simplified. They should provide witness protection. If witnesses know that if I come and testify, I will be protected, they will be willing to come and testify, and more cases will come up for prosecution. And Cameroon should review any existing national legal framework that is still discriminatory. Cameroon, as a state, should map out and mobilize all available pro bono legal service providers. By mapping out these actors, a picture emerges of who is available, where they are, what are they offering, who does what, and what do they offer. This will also show the geographical and jurisdictional gaps in service delivery and inform prioritization of resources. They should simplify accreditation processes for civil society organizations that deliver pro bono services. Registration of these organizations should be made easy. They should provide legal aid specifically targeted at women and girls. Establish legal aid clinics in rural areas where those people who are affected they live. Should have aid closer to them. There should be continuous capacity building for all stakeholders. The state of Cameroon should promote a system of close collaboration. Collaboration, I always say, is key. No one actor can win this battle alone. Collaboration among social service workers, legal aid providers, prosecution, and the judiciary, plus the health services is very important. The state should train police officers to deal with sensitive cases and vulnerable people in a non-threatening environment. Many people are afraid to come and report because of the hostile environment in which investigations are being carried out. So we must scale up trainings on GBV case management. Proper investigation of cases encourages survivors to report and assess justice. We should expedite trials. Slow judicial processes prevent women, especially in rural or conflict-affected areas, from seeking justice. What are the recommendations to civil society organizations? Continue raising awareness in local communities about sexual and GBV and gender-based violence. Encouraging communities to report such matters to the police authorities. Train more paralegals and place them within those inaccessible communities. Strengthen formal and informal justice systems. Support women's representation and leadership within formal and informal justice systems like customary courts and traditional councils. Carry out sensitization on existing legal aid law that we say is so cumbersome, and lobby the government for the procedure to be made easier. The civil society should also scale up pro bono services. Many of us should be able to give back to our communities. We should update and publicize referral pathway of support services yearly. Because if you don't access services, all of these services, you cannot. Fighting GBV or discrimination must be a holistic something. We must be able to tell them where to access what service. We should offer entrepreneurial skills to women and girls. Once we empower them economically, they can be able to access justice with their own means. Provide remote services through paralegals. We should sensitize communities on the specific human rights problems faced by women in different spheres of life. Then we must familiarize communities with existing international, regional, and national legal texts designed to protect the rights of women. Laws really matter, and if they don't know these laws that they exist, they cannot claim them. So once they know it, they'll be able to access justice. We must enhance awareness amongst judges, prosecutors, lawyers, and police officers of acts and practices that violate fundamental rights of women and girls, highlighting their own potentials as judges, prosecutors, lawyers to contribute to improve protection of women and girls' rights. Yes, they have a big role to play, these particular actors. So once they handle these cases in a good way, good proper case management, women will be able to access justice, and then we'll be able to make equal access to justice a reality and not just something that is lying in the law books. I thank you all so much for your kind attention.